I'm going to begin by saying that the world that I'm currently inhabiting is this world of what's called the UN Guiding Principles on Business and Human Rights. They were endorsed by the UN Human Rights Council in 2011. A professor named John Ruggie, who recently passed away, was the architect. But the key thing is that they were sort of a consensus-based framework that was sort of law, but sort of not law. And the framework, which is called the Protect, Respect, and Remedy framework, I'm not going to go into what the framework is. I'm going to talk about why it's now becoming binding and why that's why you might want to pay attention. But the key idea was that John Ruggie took corporate law principles and said that companies needed to think not only about risks to company, right, but risks to people. So supply chains is where the discussion's happening these days that we think about, is there modern slavery in your supply chain? So he created this concept of human rights due diligence, where companies were going to look at their business relationships and their business activities, and even if there was just a linkage, so not just to a human rights abuse in that relationship, then there was a duty to prevent it, mitigate it, and provide access to remedy, possibly. Right? So the idea was using this tool of human rights due diligence, which the corporate lawyers here are going to think about is what you do as a business risk prevention tool, into thinking about risks, not to the company, but risk to people. So all I want you to think about, if you haven't thought about the guiding principles, is take a look at it. It's a framework, and it is something that you're going to hear from Christian and Peter about, is what they use in thinking about human rights impacts of their businesses and their sectors. So it's a framework, right? We have corruption frameworks. We have a business and human rights framework. We're a decade later, and we've seen what this framework has done is that for governments, for companies, and for civil society, it has created a common language, and language, as Christian, I think, mentioned earlier as we were chatting, matters, that companies use and governments use to think about how we're going to deal with human rights abuses in this business sphere, so supply chains, for example. And so that language is going to be important, and I would say if you take away anything from today, it's learn about this language, because some of your colleagues who speak it mean different things than what you do. Second slide. Have the concepts of anti-corruption and business and human rights ever been connected? They have in a couple of places. One, most notably, the OECD guidelines on multinational enterprises. In 2011, an additional chapter was added to these guidelines on human rights. So in an instrument that deals with what's called responsible business conduct, we have both corruption and human rights in the same basket. The UN Global Compact has both a respect for human rights and anti-corruption as some of their principles. So at least at the largest conceptual level, we have this idea of RBC, responsible business conduct, that marries these issues and says both of them are important as part of this responsible, sustainable business ecosystem. But we don't have much more than that, right? What we have silos. So we have these issues floating around. We have people, and we have civil society groups, Transparency International does work on this, that say, yeah, the connection is when businesses are engaged or connected to corruption in partnership or not with governments, there are human rights abuses, right? So the conceptual issue is there, but it hasn't led to action of connecting the dots. Well, why should you think about connecting the dots and learning about these issues? Well, it's because the guiding principles are now becoming binding law. We have a whole host of new rules that are being created around the world, most notably in Europe, around this concept of mandatory human rights due diligence. So we have a law in Germany on the supply chains. We have a law in France called the law of vigilance, which requires companies not to voluntarily, but to have to look into their business activities, identify human rights abuses, correct them, and if not, possibly be subject to administrative or other legal sanction. So just like we think about corruption and compliance, we now have compliance coming into this business and human rights world. And so here you have just a thing saying, look, right now we're in the midst of a debate at the EU over a draft directive in this field, and then we have a map over here showing you different legislative initiatives. We have other flavors of these. You're probably more familiar with modern slavery laws. And then we have new laws in places like the United States around, are your goods made with forced labor? And if they are, for example, the Uyghur Forced Labor Protection Act, then you might have to think about the human rights due diligence in your supply chain because your goods won't get into the market. So again, this is not a lecture on I want to teach you everything about BHR. It's just to say that there are connections in terms of the end result. Bribery and corruption lead to serious human rights abuses. We have parallel paths to address these two different harms or manifestations of business activity in the world that are siloed. We have some attempts to bring them together through things like the OECD guidelines, but that hasn't led to much. And now we have the business and human rights field catching up with corruption in terms of the issues of compliance, right? That we're now starting to see at a much faster pace a binding set of rules that are coming. And we're seeing actually companies saying things like, oh, we now support mandatory rules because now that we have a few national laws in places like Germany and France and the Netherlands, companies are saying what they said in the corruption field. We now want a level playing field. We want harmonization. We want competitiveness. So we do want rules now. And so you're seeing that. So we're seeing this speed. So in 2020, my working group, and so I work with many of the companies in this room talking to the people in your shops that deal with human rights issues. And so we wrote a report which was meant to say, let's connect the dots between business and human rights and corruption. And so here are just examples of a company, again, pays a bribe to avoid an environmental impact or safety assessment. That leads to a dam collapse. That happened in Brazil with a particular dam. Bribery or fraud in the pharmaceutical supply chains, we heard about that from Andrew Blasi and others, leads to diversion of essential medicines or supplies. So our report connected the dots, and I'll be happy to provide a link to it, because we had a series of recommendations to companies, to governments, and to civil society. But I'm just going to stop and say, here are my 5 main points, and then we'll hear from two experts about the private sector is, what about collective action? So my biggest point to you is that collective action is a term and a concept that you know well, but it's not as if that's not happening in these other spaces. It is happening in business and human rights. We just use different terms. Christian mentioned the term partnership that's often used. Another term that's used in the business and human rights world for collective action is called multi-stakeholder initiatives, MSIs. That's the term we use, which is that you bring government, civil society, and business in different ways to the table. You come up with consensus-based principles, sometimes enforcement mechanisms, codes of conduct. Sometimes it's industry-based trade associations working together to solve problems or to help SMEs. But it's just to say, there's collective action in business and human rights too. We just call it something different. So, my 5 points. Number 1, integration of business and human rights and anti-corruption into an integrated risk management and compliance within a company and with government and trade association activities, I think is something that should be explored as we move into this new decade with business and human rights. As we move into a world where business and human rights becomes rules-based and compliance-based, there's just questions for your company about, is it beneficial to integrate these two issues into your risk management processes? My hypothesis is yes, efficiency, but also what we've seen is that when you do human rights due diligence, which means consulting stakeholders and asking rights holders on the ground, what are the impacts of our business activity? So imagine a mining company having a consultation. They're going to tell you things that help you improve your processes. They know about corruption risks as well. So why wouldn't you ask when you're doing a human rights impact assessment about a corruption risk? Similarly, for your compliance and risk management teams, certainly certain complex markets with high risk of corruption, if that risk is there, then you may need to think about certain kinds of due diligence because there's likely going to be a correlation with strong human rights abuses on the ground. So it's just about, is there going to be an efficiency and a symbiosis? I think from the UN side, yes. The second is learning from each of these fields about good practices. So don't think that there isn't innovation in business and human rights, that you probably have much to learn about from collective action and innovation in the BHR field, which is also about challenging environments and challenging issues. One of the challenging issues now, again, is sort of very difficult markets where you're not often able to figure out how to deal with those risks of things like forced labor in a particular market in Asia. What are the tools and the tactics and the methods for identifying those risks when you have lack of transparency? So learning from both fields. Point 3. We have these collective action or multi-stakeholder initiatives in each often in parallel in different sectors and different regions, but maybe there's an efficiency about thinking about them together. So let me just give you 2 examples. One is in the extractive sector. So you heard about EITI. Well, EITI, transparency, governance, et cetera, is wonderful. But there's a separate multi-stakeholder initiative called the Voluntary Principles on Security and Human Rights. It deals with the same sector, but it deals with the human rights implications of how the extractive industry operates on the ground with security. Okay. There are probably bridges that should and can be built between these separate initiatives. And often the same governments are involved in both, but having different conversations. So how do we synthesize and integrate some of these issues, or at least begin those conversations? Because the transparency pieces that are happening on one side are important to the other. Beneficial ownership, for example. Civil society groups that care about human rights care a whole lot about knowing who owns the company that caused the harm. So collective action around policy reform is important. Second is construction. I worked on those APEC principles that Andrew spoke about when I was in the US government. I worked on a set for the construction sector, and we had the Hanoi APEC principles. Well, the construction sector has a new initiative focused on human rights issues and what they call worker welfare. So they have another initiative. So they have their construction initiative, their human rights initiative. The question they're asking now is, can we build one into the other? Probably they can. Finally, last 2 points. Grievance mechanisms are also a site where I think companies are thinking about integration. When you think about how complaints and problems come into the company, the question is, do you need multiple routes or one? Open question. And finally, as I mentioned, mandatory human rights and environmental due diligence should be a strong impetus for more collective action and connecting the dots. So I know this is a high-level overview. It's meant to be, just to say again, that we hope that this journey will be one that is, if not integrated, at least symbiotic. And so look forward to your questions, and again, thank you for the invitation.
Thank you very much, Anita. So now I'm turning over to Peter. You have a lot of experience in business and human rights and now working with Novartis. So if you could just walk us through your current engagements and your thoughts.
Yeah, sure. Sure, thanks. I'm reminded of the Mark Twain quote that experts are just people from out of town who stand at the front of the room. And that's certainly the case here, because in trying to integrate human rights into anti-bribery programs, it is still very, very early days. And so I would not consider myself an expert here, and very much looking forward to the conversation and getting some ideas from this panel as well. Let me make 2 kind of overview points, and then I want to talk a little bit about what we've done at Novartis to try to bring these 2 worlds together, as Anita so clearly laid it out. And then perhaps more importantly, what we plan to do, which that list is a little bit longer than what we have actually done. But first, I just wanted to say, I mean, this integration of human rights into anti-bribery programs, especially existing anti-bribery programs, is not obvious of what to do. So Anita laid out this idea that there are human rights impacts or human rights harm that can occur when bribes are paid or corruption occurs, and that is true. Coming out of the business and human rights field, I've very much become a pragmatic idealist, right? And so idealistic, like, yes, this sounds great, human rights and anti-corruption, we need to link this up, but on the pragmatic side, operating within a business and trying to give people guidance on what this actually means, I can sit down in a training and say, there's a potential human rights harm to corruption here, and they say, I know, that's why we're trying to prevent it through our anti-bribery program. So where's the there? And that was not obvious to me, at least initially. I think a lot of other people who were working in business and human rights. The other challenge is business and human rights is still relatively new. The guiding principles were adopted 11 years ago that Anita mentioned. Novartis has been formally working on a human rights program for only 5 years, and that's a long to-do list in and of itself, right? Getting everyone on board with identifying human rights issues, getting the right policies in place, doing training, conducting due diligence, doing stakeholder engagement, monitoring, tracking, building all of these systems, and then to have to figure out how to integrate that into an existing anti-bribery program. Again, I think a lot of people just said, okay, what exactly does this mean? I am very grateful to you, Anita, and the working group for the report that you put out in 2020. For anyone working inside a company specifically and looking for a little bit more of that concrete, like, what do you actually do here besides just tell people there are human rights impacts? I would point you to the working group report and to the OECD BIAC report that came out specifically on this issue. We recently ran a gap analysis against that report and have now come up with a number of different things that we can do. So let me get into a little bit about what we've done and then a little bit more about where we're going. So the first thing we did is I should also say we have a very strong, robust, long-standing anti-bribery and corruption program in Novartis. So we, in 2021, pulled together that group of experts, specifically the experts looking at third parties and monitoring and doing due diligence on third parties for anti-bribery. And we held a capacity building workshop on human rights. Here's what business and human rights are. Here are the potential impacts that we see. And we wanted to run a little pilot project without putting too much governance on it, just to open it up and say, go forth and in your day-to-day world, as you are reviewing third parties for us and conducting anti-bribery due diligence, if you think you might find something where there's a human rights connection, let us know. I placed a bet with the team that no one would call us back because I thought they're just not going to get it. Like, they're not going to be able to see that that there's a connection there. We ended up getting 3 cases that came back in, and so I stopped betting my team on how well our colleagues can pick up these concepts. We didn't end up getting involved in those from the human rights side, again, because I think that takes it to a different level of, okay, now that we've identified that there's a potential bribery case that has a human rights element, what does the human rights team exactly need to do? So that was just sort of nice to see that we can link those things up and we can get people to help us identify human rights issues that might have a bribery component. The second thing we did is we took a look at the questionnaires that we send out to our third parties, specifically our anti-bribery questionnaires. And we wanted to make sure that we were asking questions from a human rights standpoint that were getting us good answers. We did feel like the questionnaire was pretty good. We didn't add any specific human rights questions, but there was a section added that is now in our third-party questionnaire that asks for a lot more detailed information about the management program at our third parties. So various policies, processes, who's managing it, what's the governance, and we can then take a look at that, hopefully over the next couple of years when we get more involved, from a human rights standpoint and say, all right, if this third party has all of these people looking at corruption and anti-bribery, maybe they don't need to build a whole new human rights department. We can piggyback onto what they're doing in the anti-bribery space. So that's now in the third-party questionnaire. We still need to figure out what we're going to do with some of that good data. The last thing that we did was link up coming in the other direction. So how can we use anti-bribery due diligence that's already occurring in our human rights due diligence? So we conduct human rights impact assessments in countries. We pulled data that the anti-bribery team had identified so that we can get a more robust picture of what the potential human rights impacts are in those countries. And then we also, as Anita recommends, we will ask in our human rights assessment interviews about bribery and corruption and try to get a better handle on what the situation is in a particular country and try to figure out if there's a way we can design a mitigation program or an intervention that includes both a bribery and a human rights component. So those are the 3 things that we've been able to do over the last 18 months. What we plan to do is continue the capacity building. I think that worked. We want to do more throughout the year, 2 to 3 sessions, and do more around scenario planning, more around really digging into what pieces of evidence or criteria would we like you to look for when you see a potential response on a third-party questionnaire or in other due diligence or in public documents that comes in. What evidence do we want to see that's going to flag, hey, this could actually have a really serious human rights harm? So there's more training that we plan to do. The second is we've designed an escalation procedure now where it's a formalized procedure where the human rights team will get involved once we roll it out in specific cases as the anti-bribery team is flagging them. So that will give us a seat at the table to talk a little bit about potential interventions and maybe remedy. The other thing that we're doing that we found is that human rights plays an interesting linking role between a number of our different risk verticals. So in our third-party risk management program, we ask third parties about 7 or 8 different issues. We've identified 4 of those as having really critical human rights elements: labor rights, HSE, health and safety and environment, data privacy, and anti-bribery and corruption. What doesn't currently happen in our system is that if there is a supplier or a third party who is flagged as high risk for labor rights, the anti-bribery team or the HSE team or the data privacy team doesn't necessarily know that. So what we're doing through this escalation procedure is that when we get called in, say an anti-bribery expert has identified a third party as being high risk on anti-bribery, we want to take a look and see what their results were from labor rights, HSE, and data privacy. And if it suddenly turns out, hey, wait a second, this supplier is high risk on all of these areas, do we really need to be doing business with them? That's a value add that does not currently exist in our third-party risk management system. So that's something I'm really looking forward to get in to do and to see if we can play that linking role. The final couple things, one is building human rights training into our third-party onboarding through the anti-bribery program. So when they find deficiencies or gaps that need to be filled, we can include some human rights training in the pack that they send out to third parties. The final thing, and actually I want to add one more point here that I was inspired by with your talk, Anita. But the other point here, and this is more of an academic one, sort of the idealistic side, I guess, is on remedy and thinking about remedy and human rights and anti-bribery and what approach, a human rights-based approach to remedy might bring to the conversation. So from a human rights standpoint, we are looking at how a specific rights holder or person was harmed. And they are entitled to a remedy that returns them to the same position they were in before that harm occurred, to the best of our ability. You don't always see that in anti-bribery. I mean, it's often called, I know none of us believe this, but a victimless crime, right? It's not a victimless crime. There are people who are harmed. But are those people at the table, or are they directly gaining access to some of these multi-millions or hundreds of millions of dollars of settlements that companies like Novartis, unfortunately, have paid to governments? Is there a place there to make sure that some of that gets back specifically to the victims who may have been harmed, and maybe even more importantly, to identify who those victims actually were? And that's more of a longer-term, bigger picture conversation. The last thing I want to close on is just a point I jotted down, which is maybe there's something here, maybe there's not a whole lot to do on the internal integration side. I think we've mapped out a pretty good approach, and I'm excited to do it, but maybe a lot of it is just connecting with this community and bringing these two worlds together and saying, how do you do better on collective action? You all have been doing this much longer than we have. You all have really robust due diligence processes, good ideas on governance. What can you sort of teach us on the human rights side? And so maybe there is more here on this external engagement that goes sort of hand in hand with this internal integration. So let me leave it there, and happy to take on questions.
Well, thank you very much, Peter. And I think there is value in collaboration. And as Anita mentioned earlier, I mean, we can call it different names, but working together, there is always value in working together, and very interesting to see that you're currently building on existing, maybe very mature anti-bribery and corruption programs to look at it from that sense. And I think the other way around as well, there is also value for anti-corruption practitioners to also learn from business and human rights practitioners. So I think that's what we'll delve into later on with a set of questions. But moving on to Christian. So Christian's also been very active in multi-stakeholder engagement, and notably with the Thun Group as well. But maybe if you could just walk us through what UBS is currently doing in that space and what you're currently working on.
Sure. I mean, just a few comments to start off with. I'm glad that the organizers put Peter first, because I sometimes feel, that people put banks first and the real economy second. I think the real economy should be first. And I remember, and Anita, you can tell me whether I'm wrong, but when the UNGPs were developed by John and his team, they spent 65 days with the mining sector. They spent 1 day with the financial sector, and I was there in Geneva, so on that one day, So I think that's turned around quite a bit. If you mention the OECD, as was mentioned, I think the largest number of NCP instances at the OECD are now about the financial sector. So I think there's an interesting discussion to be had of this notion of the lever, but we can come back to that in a moment. Second point, as a historian that I am, and as somebody that looks after the sustainability report of our bank, I don't normally make forward-looking statements, so that's about the future, because what historians know probably better than economists is things go differently, than what you predict. And there's maybe economists would call it tail risk. Historians don't call it that. They just call, don't try to predict the future from what's happened in the past. But anyway, we hope we can make a few comments around that. The third one, UBS is a bank to anonymous. Yes, there is a bank here, us, me, as representing the bank, and we're the largest bank in Switzerland. So just because anonymous asked that, I think I should explain that UBS is a bank. It's not UPS, it's UBS. We're the largest bank in Switzerland. We are across 50 countries worldwide. We have 72,000 employees. Our main focus is on wealth and asset management, so that's probably just to, and we are, a universal bank in Switzerland, so that's why probably, according to one survey, 98% of people know us. I don't know who the other 2% are. They probably live in the mountains. But anyway, so we are a bank, and I think that's an important one. Fourth point, Wolfsberg Group. Actually, we are, co-founder of the Wolfsberg Group. It's actually named after our conference center, so I can throw that in. Wolfsberg, which is on the shores of Lake Constance. So that's where the name actually comes from, for those of you who have not heard about this before. I've just actually come from the inaugural Wolfsberg Forum for Sustainable Finance, same place. So I think just to connect the discussions a bit, although I have to say that discussion was very, very heavily, and I think that's a telling sign of where we are today, around climate. So it's like climate, 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 and then nature. And then maybe just transition as an add-on. But that's an interesting one, maybe also in terms of the broader discussions. Now, my CEO would probably shoot me for this, because I'm sort of kind of, taking apart a bit our sustainability strategy. Our sustainability strategy is based on the 3 pillars of planet, people, partnerships. What I will call it now, a bit duller, it's processes, people, partnerships, Because I actually believe, and even though it sounds like a very dull word, processes is the most critical piece in all of that. And I think, Peter, you've highlighted that already. And so therefore, one of the first things that we did out of the Thun Group that you mentioned on banking and human rights is really look at the whole due diligence concept. Because I think more than anything else, and it's not surprising that on the climate topic, that when the task force on climate-related financial disclosures established the framework, which is to me the framework, I think it's the best framework to look at sustainability across any given organization. And actually the TNFD that has now been established on nature will use the same framework. The very first thing that they put there is governance. Not anything else, before strategy, before anything else, governance. And I think this is an extremely critical point, because if you're not embedding these processes in the governance of a firm, you're not going to get much far. So I think that's why I keep saying this is critically important. It sounds very dull, policy frameworks, etc., etc. But without that, it's going to be very difficult. So therefore, we do, of course, have policy frameworks around financial crime prevention and policy frameworks around sustainability and climate risk. And that includes, of course, on both sides, the human rights topic. That's what we call in a bank second line of defense, which I think is also an interesting term. I'll come back to the first and the third one in a moment. Second line of defense is really those functions, that are critically important in managing the risks that we're talking about, Anita, so the compliance and risk functions. And in both cases, human rights are part of the framework, of the policy framework. We actually publish, particularly the Sustainable Climate Risk Policy Framework is a public document, so you can find that on our website, and we have 3 pillars. It's climate, biodiversity, and human rights. So I think just on that side of things. So I think that's a critical one. Second point there is very close interaction. And I think an important interaction, not just among the functions, is actually across data, information. Because if there's one piece that's absolutely vital to the entire discussion, it's data and information. So we are still, I believe, the only bank in the world, maybe somebody's in the room that will contradict me, but I believe we're the only bank in the world that actually has integrated the whole human rights and environmental, so the entire space of environmental, social, human rights topics in our compliance tool. So the tool that was established to essentially identify terrorists, criminals, money launderers, etc., is the very same tool that actually also yields information on companies and individuals that potentially violate human rights or environmental matters. And we have an automatic feed, from a tool that so just mentioning myself here, that I tasked to be developed about 15 years ago called RepRisk. So there's a feed from there into our tool and really sources all of what we need, for that. What's important about that one, and that takes me to people, is of course that, and that's again why processes are critical. Now, everybody at the client-facing end of the bank that puts in a client or a potential new client, into the compliance tool, as they have to do to check, whether there are any concerns, will automatically get, and I call it now a red flag, not just if that person is potentially a terrorist or a money launderer or a criminal, but also if that person or company, more often than not, is also potentially violating human rights or, environmental matters. And I think that automatically means that the person in that so-called first line of defense, that is the average employee, will then automatically have to take a decision on that. And the decision may well be just not to continue. So the prospect doesn't become a client. That's without even including the risk or compliance functions. But of course then, the step that the person can take and will take quite often is to escalate, to your point, to the respective function for this to be assessed. And escalation here can mean that it can go all the way up to the CEO, depending on what kind of matter it really is. So again, this whole notion of connecting the processes with the people is an absolutely critical one and should not be underestimated. Now, having said that, I think, and I'll come back to that in a moment on the partnerships, I mean, the data situation is generally, I'm sure my colleagues in compliance would disagree, but generally better on the sort of the anti-money laundering, the financial crime prevention side than it is on the human rights side, because of course there is more that states, for instance, identify around that, sources that you can use. But still, you have to be able to expand this as much as possible to make it possible. The other one around people, and Peter mentioned it, is clearly training. I mean, trainings around financial crime prevention are mandatory anyway. They've been that way for a good number of years, but also what you find is that trainings that relate to the human rights topic or the broader sustainability topic are now very much embedded across the firm, and so therefore also very critical in that respect. Actually, one other thing which connects the two is, of course, the sort of disclosures, transparency. And one thing that we've done is starting off with, I mean, actually, well, again, sounds very dull, ISO, but I think ISO actually is very helpful. So we started in 1999 to apply ISO 14001. We were the first bank to do that globally across all our operations. Now, ISO 14001 is actually about the environment, but what we did is to say, okay, but then as we're connecting this with the human rights topic, this should also be included in the processes. And since 2019, we also apply the respective ISO standard, what is it, 37001, I don't know, on anti-corruption. And of course, also that looks at all the processes within the firm. And I tell you, this is a critical piece because it's not done internally. Of course, it's done by an external party, and the results go all the way up to the board. So again, I think those processes and the transparency that comes with it are very critical. I think why I mentioned, made that comment about the real economy, when you look at people, of course, you come to clients, and clearly we're very heavily, in many ways, reliant on exactly what Peter described, because at the end of the day, what our due diligence people are ultimately assessing are the due diligence processes of companies like Novartis. So if they get it wrong, how does that pop up at our end? And then, of course, civil society, and my team looks after the entire NGO, civil society dialogue for the bank, so that whole stakeholder engagement. And finally, partnerships, as we call it. The Wolfsburg Group was mentioned. That's one good example. The Thun Group was mentioned. Another good example, But I would also highlight things like JIMLIT. Sounds wonderful, What is it? I have to read this because it's really the Joint Money Laundering Task Force Operations Group. I like JIMLIT a lot better, than the long name. But this is a very critical piece, particularly where the UK has been very innovative in working with financial institutions in the financial crime prevention space, and also sharing information, which is not always very easy for governments to do, because they should actually be the key source, for us to identify that. Or the European Bankers Alliance, on modern slavery or against modern slavery and human trafficking, another one. And actually also, and partnerships can go into quite a number of directions, Our UBS Optimus Foundation, one of the largest foundations in the financial sector, a client foundation that actually has 12 partnerships in countries such as Uganda, Nepal, Vietnam, and so on, around preventing human trafficking. So actually, when you take the word partnerships, it can take you into a whole direction or different directions of travel. But at the end, to Anita's point, it is usually multi-stakeholder. It's not bilateral. But I think that's an important one on a whole host of levels. Be it that data issue, how to get to the right data, be it helping people on the ground, be it exchanging, understanding good practices among institutions. So I think there are a whole host of different layers to that aspect. And I'll stop here. Thank you.
Thank you very much, Christian, and thank you for mentioning the importance of partnerships. But I think I'd like to set maybe a few questions there and taking a bit of a step back, because Christian, you mentioned the aspect of governance, and also Peter, you mentioned getting a seat at the table. And so looking a bit, taking a step back, and how do you actually get started? Because Anita mentioned the different legislative changes, and it feels sometimes like a moving target. And some here might already be working on business and human rights, some might not. So how do you actually get started when it seems like the approaches that most companies have is very much siloed? So maybe we could kick it off with Peter, if you have any thoughts on that.
Sure. You mean specifically on human rights and sort of integrating that into the company? Yeah, I mean, it's gotten a lot easier, I think, over the last 11 years, particularly because it's now legally required in so many jurisdictions. The German supply chain law will come online next year. That will cover a lot of companies in Europe, certainly Novartis. Anita mentioned the French law. We have the UK modern slavery law that was one of the first. There are other public procurement requirements, regulations that are now in place. And then, of course, this overarching EU human rights due diligence, mandatory due diligence. So that is where you start the conversation, I think, to say, look, we've got about 4 or 5 years here before the EU adopts the directive and before it actually becomes law in the EU states. Let's get started now. This is not a trend. Human rights is not a trend. It's serious. And the guiding principles have been phenomenal at allowing and creating a space for business to take this up voluntarily. It's not enough. It's not sufficient. But you can also point to your peers, I think, relatively quickly and say, we're not the first mover here. There's a number of other people out here, other companies that are working on these issues. Finally, then it's always helpful to have external stakeholders, specifically investors. We've gotten more investors over the last couple of years that have asked us specifically about human rights or specific human rights issues in our response, that it was necessary to have some thoughtful approach on that, to have a team on that. So those are the 3 levers I've found to be most helpful.
Thank you. And moving over to Christian, do you have any thoughts on this?
Yeah, maybe just following on from Peter's point, I mean, our institutional asset management arm probably is one of them, I would imagine, I'm sure they have shares of Novartis in their funds. So therefore they have a human rights program. And as they have done for many years on the climate topic, partnerships such as Climate Action 100+, you can see that now evolving very strongly in the human rights sphere, the Investor Alliance on Human Rights, but also the sort of specifics that asset managers like us, or the asset management arm of the bank, does. And that's also going to intensify. So there's that, and there's also the Good Works program, which is really more about looking at how companies interact with their employees and their suppliers. And again, it could be Novartis, I can't say, but I'm sure there's a good number of companies on that list. So I'd say, but as somebody that is actually at the other end of that discussion, and that is I sort of, and my team, and together with our investor relations people, we constantly have these conversations with investors. So then, of course, they come and ask those questions to UBS. I have to say, to add on to Peter's point, it's become a much more sophisticated discussion just over the last 2-3 years. And I have to say, if you ask investors, they will say climate, 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 and then there's a long pause. So let's be also fair. The main discussion today is still very much around the climate topic, and I think it will be for a good number of years. The other point that I'd like to make about really embedding it in the governance and that kind of integration is, I think the bank, in hindsight, did a pretty clever move after they signed the UN Global Compact in 2000, so among the initial signatories, is they said, okay, then we also need a committee at board level to really look after that, you know. I don't think they knew at the time what they related themselves into, you know, because if you establish that, then it creates a whole new, you know, interaction within the company. But so today we have at UBS the Corporate Culture and Responsive Committee that you mentioned, sitting alongside the Risk Committee, the Audit Committee, the Comp Committee, and the Governance Committee, and they are often joint sessions. So anything, and this is an important point, anything that is discussed around human rights and anti-corruption and financial crime generally is done in that sense in a joint session of the Corporate Culture and Responsibility Committee and the Risk Committee. You know, so again, that's where the interaction is happening. But of course, that means it clearly also has a very direct filtering down into the organization.
So I'll just add a couple of other, again, how to get a seat. The first one is that as we look at these new mandatory rules, liability is going to attach to harms that are caused by companies that failed to conduct their due diligence. So if there's something that a board and governance needs to know about, it's this issue, liability. The second is the change in disclosure. Now that we have non-material ways, we have these social disclosures, right? Double materiality. If the board has to sign off on social reporting, that's going to be another risk that they're going to need somebody with a seat at the table. And the third is that in addition to these binding rules about what companies have to do, increasingly what we're seeing is that a company wants a government contract. So government procurement, things like export credit, trade support and assistance, all of these things are now being tied. They've been tied for some time to integrity pledges, right? Companies that want to do business with governments have to sign integrity pledges. What you're seeing is that alongside the integrity pledge is now coming a respect for human rights and an alignment pledge as well. So it's just about the fact that all of these issues are basically becoming as important as anti-corruption.
That's great to hear, and I think it's very encouraging. We've had side discussions with some of the participants as well who are quite interested in hearing the importance of business and human rights, and I think are quite keen to engage as well. I know we're getting a bit short in time, but we also have floating mics for this session, so I don't know if anyone has any questions for the panel. I see a hand over there on the right. And in the meantime, Christian, there's a question on Slido for you. So
I have no idea. I'll ask my governmental affairs colleagues, you know, so not something that sits with me. So whoever's asked that, you know, can tell me afterwards what this is about, and then I can check.
Please go ahead with the microphone.
Yeah, hello. My name is Vera. I'm an ethics and compliance consultant. Peter, I think you nailed it on the head with the statement that corruption is a victimless crime, yeah? And I think part of the problem is that we've been focusing too much on this perspective for years. We've been focusing too much on the bad actors and trying, you know, to catch them and to punish them, not identifying the victims of those crimes because, well, we said like they're too numerous, too difficult to identify, things like that, right? And it seems that right now the recognition of the fact that this perspective is not, you know, working 100% of the time is growing. For example, quite recently, the U.S. Assistant Attorney General Kenneth Polite said in one of his speeches that the DOJ needs to focus a lot more on the victims of white-collar crimes, right? So it seems that they get it, and the things will be moving into that direction. And I personally found that focusing on the victims, on flesh and blood victims, when I do the training sessions, for example, on anti-corruption topics, makes the whole anti-corruption argument a lot more compelling because, you know, people got really tired of hearing that bribes are bad, don't do bribes, things like that. But if you show them the real people, or I don't know, animals or whatever, right, who suffered from corruption misconduct, it makes your argument a lot more compelling and people engage because people sympathize with the other people suffering. Yeah, that was basically the observation.
I think it's a great point on the training, and I think as we develop some more training, we will take that on board. I want to defer to Anita because it's actually a major point that you make in the working group's report on this about remedy.
And so, as an academic, I do research on this, which is in the area of business and human rights, there's already an affirmative idea that victims have right to remedy, effective remedy, either from the government or from companies, right? That it's there in the guiding principles. In the corruption space, we don't talk as much about that, right? There is literature around, should settlements involve, victims, right? But aside from that, but what you're now seeing is cross-pollination. So two things. You're seeing corruption-based remedies in places like the UK and others now being used by NGOs and others who are representing victims where there's been bribery, but also strong, significant sort of human rights impact. Issues relating to Dan Gertler and the DRC. There are cases now that are being mounted in the UK. So I think you're going to see hybridity where victims of bribery will be starting to use business and human rights processes to seek civil or administrative remedy against companies so that civil society sees these issues as blended, even if we don't. And so I think in that sense, we should start to see it from their view.
Thank you. And I think we're basically almost at 12, so we won't be taking any more questions. However, we'd like to get some closing remarks in terms of where you think there might be opportunities in terms of connecting the dots between both the business and human rights aspect and anti-corruption. So if we could maybe start with Christian and then all the way.
I think, there was also a question about the motivation. I mean, it's almost, I feel, a self-explanatory one, but Anita is the expert. I mean, I would imagine that there is probably no case of corruption around the world that doesn't involve some human rights violation, So I suppose there is an obvious reason to link those two fields, I think in essence, maybe using that analogy to climate again, what's been very successful, and actually Anita's one slide showed where things are not very successful, I believe, although I think you've positioned it differently, is of course we now have a uniform framework around climate, and that's how, financial institutions, increasingly companies in the real economy, I mean here in Switzerland it's certainly going to be implemented like that, need to implement and establish and look at the climate topic across a company. And you'll see the same, as I said, on nature. I once talked to the anti-slavery commissioner, well, actually last year I talked to the anti-slavery commissioner of the UK, and we would both agree that it needs something like that actually for the human rights, in this case modern slavery topic, where you see these things integrated. So I think companies that really want to move the needle, they really should look at that model and think of what it actually implies, It's governance, it's strategy, it's risk management, it's metrics and targets. It's very, to me, well, it's not as simple when you look at the entire framework, but if you look at the overarching framework, it's actually something that's very intuitive. And, I always wonder why it's not something that is applied across the board on all those sustainability topics, which is maybe an answer to that ESG question earlier on.
Just very briefly, look forward to continuing the conversation. If anybody wants to reach out to talk about human rights or how we built our program at Novartis, I'm very, very happy to talk one-on-one or in a small group. But thanks again for the great discussion. Some really interesting ideas coming out of here today, and I hope we can keep this topic on the agenda going forward.
Thank you. Anita?
Yeah, I'd say, and Peter mentioned this, which I would say that I've said a lot of what we have to say as a working group in our report with very specific things about how we integrate in the compliance function these two different topics, but just three little takeaways. One is that our working group has been spending a lot of time with governments. There's a lot they can do on what we call policy coherence and how they interact with the private sector on corruption, business and human rights. And so just to give you an example, a few days ago, Peru was one of the first to have a national action plan on business and human rights, but it integrates a strong anti-corruption set of tools as well. The second is we need strong connections on policy reform. Again, the working group's report really makes this point. Issues like beneficial ownership reform or issues around remedy and the role of victims, all of that, there's a coherence around if we get these policy reforms through, it benefits both of these worlds. And finally, just as Peter said, I think there are very specific and concrete steps where it makes sense for that connection within a company. And so, again, as someone who comes from an anti-corruption world, but in this world now of business and human rights, always happy to engage with you on, kind of your next journey. So thank you so much.
Well, thank you very much, and we engage everyone. We encourage everyone to continue the discussion. Of course, it's not over, and I know a couple of more people had questions, but it's definitely not over. We just have to close also today this panel. So please join me in thanking the panelists for today.